As I stated, we are here tonight for the case of State versus Young, and are the parties ready to proceed? Ms. Nye, you may begin.
Good evening. May it please the court. My name is Melinda, and I'm here representing the defendant appellant, Artel Young.
Could you speak a little closer to your mic? All right, we'll try that. Thank you.
In December 2021, Mr. Young was on federal supervised release and was being supervised by federal probation officers. On December 22nd, without a warrant, about a dozen probation officers searched Mr. Young's home looking for evidence that he possessed weapons and was possessing, manufacturing, and possibly distributing drugs. The probation officers found some evidence of these crimes, and the search took several hours. But before the search was over, they realized that the amount of contraband they were finding was not of a sufficient quantity that was appropriate probably for a federal prosecution on charges. So they contacted local police in Des Moines and turned the fruits of the search over to the Des Moines police, which were later used in a prosecution by the state against Mr. Young. Because this warrantless search did not fall within the scope of the special needs exception to Article 1, Section 8, the search violated Mr. Young's rights under the Iowa Constitution, and the fruits of the search should have been suppressed in his state prosecution. The special needs exception to the warrant requirement of the Iowa Constitution applies only in those exceptional circumstances in which special needs beyond the normal need of law enforcement make the warrant and probable cause requirement impracticable. This court has recognized the special needs exception under Article 1, Section 8 in State versus King in a situation similar to this, which involved a parolee and a search by his parole officer. In the specific facts of King, the court held that we conclude that parole officers have a special need to search the home of parolees as authorized by a parole agreement and not refused by the parolee when it's done to promote the goals of parole and divorced from the goals of law enforcement.
What about the threshold issue? These are federal officials who are not subject to the Iowa Constitution. Do you agree with that?
Generally, federal are not. I think if we're looking at the Ramirez question in the reverse silver platter, I think there are some factual distinctions that implicate, given that the way that this evidence was turned over to local police officers. I think there's some facts that indicate not overt collusion between, like, Iowa officers did not participate in the search, but they certainly received the fruits of the search, and it wasn't unusual or unexpected that the evidence.
But that would be an exclusionary rule issue and not a actual Article 1, Section 8 violation, right?
The way that's been interpreted, correct? Okay. Well, yes, I guess that would. I mean, I think there's a way that the way these facts played out in the testimony we had from probation officers that they knew that the search, that the fruits of the search would be turned over to local law enforcement, or that they knew they would turn over the fruits to law enforcement and likely to be local law enforcement. I think there's an argument that brings this, sort of distinguishes this from Ramirez and brings us into a direct constitutional violation rather than being fully done entirely by federal officials.
Counsel, here the district court found that the federal officials were credible in their testimony, and we typically would defer to that determination. Is there any reason why we shouldn't hear when those officials said that they weren't colluding with anyone from the state?
I agree that there was no overt collusion, and the testimony was that they didn't speak with law enforcement before they conducted the search, and the Iowa officers did not participate in the search. But I think when you look at Officer Song's testimony from the suppression hearing, testified that, they got into the search and they sort of realized that this wasn't going to be, they weren't finding a whole lot. They found some stuff, but not a whole lot. And so they made the decision that to turn it over to local police, and that they weigh these decisions, that this is a matter of course for them when they're doing a search and they're going to uncover evidence.
Isn't that action of the feds you're talking about? That's stuff going on in their mind.
Yeah.
So I'm failing to see when you said that there's no overt collusion, that implies some sort of other signs of collusion. I don't see it. Are you alleging that there's something in the facts that says the Des Moines Police Department knew something about this at the time the warrant was requested, or at the time the permission was requested to execute a warrantless search, or any time during the search? Was DMPD involved?
No, I don't. I'm not saying that there's evidence. It's partly, distinguishing Ramirez, but the part of the point of suppressing the evidence and utilizing the exclusionary rule is to deter law enforcement. And in this case, what's happening, the sort of bigger picture is when we require there to be some sort of overt interaction of local officers or state officials in the federal search. What it does is it sort of pushes that collusion underground, and in some ways it's sort of a passive collusion or a silent agreement that Des Moines, that everybody knows if we don't talk about this, we'll get the evidence, because you guys have the power to do searches that wouldn't be,
So, Ms. Nye, let me ask you this, and the state brings this up, it's brief. If the federal officers are conducting a search that is acceptable under the Fourth Amendment, under the federal Constitution, and you agree that this search was, correct?
Correct.
Okay. And they find a dead body, and they bring it to the Des Moines Police Department.
Mm-hmm.
Are you saying that the Des Moines Police Department has to say, we won't investigate that? Because the Iowa Supreme Court says so.
I think this is always the fear when there's a search done that's not pursuant to a warrant, that if other evidence gets found, this is always a risk that I don't know that this is, that this has happened. I think that also, though, when we have federal parole or probation officers operating in the state of Iowa, in the city of Des Moines, where they know that they're dealing with Iowa residents, and I just think that's always a risk that.
Ms. Nye, we wrote in Ramirez, which was the other silver platter case we decided, and there we actually upheld denial of the motion to suppress in that case, that if there really is collusion, that's a problem. Mm-hmm. I just don't see it in this record. I don't see sort of a plan to evade the Iowa Constitution by having the search of this house done by federal probation officers. They sent about a dozen people to Mr. Young's house. That seems like they thought that's a lot of trouble to go to if all they were going to do was turn it over to the state. I wish we in the state could get that kind of help from the federal government most of the time. That's a lot of resources to devote to something. They clearly anticipated something different than what happened, right?
Definitely. They definitely thought, I think, that they were going to find something. But Officer Song's testimony is, at the end of a search like this, we know we're going to turn it over to law enforcement of some kind, whether it's federal or state. It'll depend on what we found. And he describes instances when we found pounds of methamphetamine that would warrant, that's going to go federal.
In that situation, they turn it over to federals, and is that a problem?
No.
Institutions? Okay. And so you had mentioned that the point of the rule is to deter officers. Is that the local officers or the federal officers?
It's overall, it's law enforcement. There's different pieces to that. It's definitely to deter state. It has to deter all law enforcement. I think it applies to state officers, but if they were actively colluding, but also
right. And that's my point. How would you deter the Des Moines police officers in a situation where they're not involved and the evidence is just handed to them?
I think it's bigger picture. It's not a direct deterrence, but it's sort of the bigger picture that if overall the goal of the exclusionary rule is to get officers to be more careful, to follow the rules, and to avoid any potential, whether it's overt or sort of more passive collusion, and that if we want Iowa residents to be protected by the Constitution, you've got to you end up by looking at how much they're participating together. You sort of push it underground, the collusion, and make it so they can work around. Like, well, if we don't talk, then we know we're going to get this evidence. And
Do you have any evidence of that even being an understanding between the two agencies? From here on out, let's not talk. Let's just both live in our own caves and we can share.
No, certainly. I mean, all we know is they didn't talk. We know they didn't talk, but we know from Officer Song's testimony that this is not the first time they've turned over evidence to local police.
Why shouldn't we extend Ramirez to this fact pattern?
I think Ramirez, besides this argument, but I think also Ramirez can be distinguished that it's not, Ramirez had to do with a potential violation of state statute. I think Ramirez also involved what was clearly a federal investigation that began at the border. It was U.S. Customs that initially encountered this contraband, this package with methamphetamine. And so the idea that you have federal officers that do practice or sort of work, in all 50 states, that you can't expect them to know local law and the specifics of Iowa law doesn't apply. This is distinguishable because we have probation officers who are working only here in Iowa, dealing with Iowa residents and Iowa property. And so that's one distinction with Ramirez. Ramirez also only involved the potential violation of a statute rather than a constitutional violation, that if the details of the search don't fall under the special needs, it's a constitutional violation.
So in State v. Brooks, we applied special needs to a search of probationers. Why wouldn't the same reasoning apply to find special needs here?
I think the extent of the sheer breadth of this search in this case, and so they searched his person, they searched his house, they searched his car, they searched his phone, they questioned his wife. He was handcuffed, and the search of the house was top to bottom, all aspects of the house. Where the search in Brooks and in King are also very narrow, and that was important in King and Brooks, that it was a narrowly tailored search.
Counsel, in this case, I think that there were some pretty good reasons to think that your client was in violation of the terms of his supervision of the community, drug dealing, and also firearm possession. So doesn't that sort of justify the sort of lengthy measures the defense took in this case?
In King, it was careful to talk about the sort of reasonableness, and part of that has to do with the scope. And so certainly drugs are hidden in small places, guns are hidden in small places, like I recognize that. But when you look at, first of all, what the officers said they were looking for, which was drugs, but it was drug notes, it was scales, it was baggies. Like, they were looking for everything to sort of prove up a case of drug distribution. They weren't just looking for violations. And there was the other thing is the lack of immediacy to these concerns. They first got word in February, and they didn't search until 10 months later. And they did very little, if anything, to investigate in that time frame. And so I think when you look at how reasonable it is and whether the other sorts of steps they took in the meantime to investigate these concerns, that also goes to the sort of breadth and the scope of the search. And could they have done something if they were really concerned about his success on probation or on supervised release? Is this really the way it would have been handled? Or does this start to look more like a general law enforcement?
Ms. Nye, do you agree that there was reasonable suspicion at the federal level?
It was, yeah, that was not challenged below. And we don't know a lot about this confidential source, which is something that would have been tested had there been an application for a warrant, but it was not challenged. The reasonable suspicion was not challenged. Well, see, I'm just about out of time. For the reasons argued here and in the brief, we ask that you vacate Mr. Young's conviction and remand for further proceedings.
Thank you. Mr. Sloven.
Thank you, Madam Chief Justice, and may it please the Court. Counsel, members of the community, good evening. My name is Louis Sloven. I represent the state. It's a privilege to be here with you all tonight. Mr. Young was on federal supervised release. The terms of that release notified him that federal probation officers, in carrying out their probation supervision mission, could search his home and his effects with reasonable suspicion to believe that such a search was necessary. These federal probation officers, in a team composed entirely of federal probation officers, plus I think maybe one ATF agent, also federal, conducted this search as part of their probation supervision mission. State officials had no involvement nor even notice that this was happening until after the search was complete. The federal probation officers found probation violations and also evidence of crimes, possession of drugs and guns. They determined on the scene that they didn't think that there was a level of offense conduct here that rose to a federal prosecutorial interest.
Mr. Sloven, they had a lot of attention before they actually did the warrantless search. 14 officers, I think they said they did pre-surveillance, they had people, I'm sure they had all kinds of activity going on. Why 10 months? That does kind of make it seem like something that couldn't have been that urgent to require all that. What's the explanation for that?
Yeah, I agree, Your Honor. I don't think their conduct in this case showed urgency. I think it's significant that they did try to follow up on those February tips with home visits. They just didn't successfully catch Mr. Young at a time when he was home, and it must have fallen off their radar. Their concern was reignited, and I think the precipitating event here was events related to the goals of probation supervision. Failure, and I think it was an arrest for OWI and a failure to appear for a randomized drug test call.
But counsel, wasn't that just the day before the search, and the search had been planned by that point, isn't that right?
Yes, the failure to appear for the drug test did come after they began planning for the search. There was also another tip that indicated to them that this was ongoing in some way.
You know, getting back to the chief's point, it was something like a dozen probation officers. I didn't know Des Moines had that many federal probation officers. You know, that seems like far more than you would need to just carry out the probation mission to determine if Mr. Young was complying with the terms of his probation. That sounds like an investigation.
Well, they were definitely equipped for a thorough search concerning the nature of the items that they believed Mr. Young had, or had reasonable suspicion of believing he had. And they left no opportunity for things to escalate to a use of force. They were concerned about potentially Mr. Young using a weapon or becoming violent. They were also concerned about potentially dangerous dogs. Now,
I'm sorry, Counsel, on that point, wasn't he in custody?
Yes, they took him into custody after he went through the magnetometers at the office. And I agree that this is a lot of agents to be involved. The district court heard the testimony of the probation officer who directly supervised Mr. Young and her supervisor, who was on the search planning and authorization team, the review team, and found them both credible when they testified that the purpose for this was to find, as part of the probation supervision mission, and that they were also prepared for anything. They also had to conduct, as part of that mission, they had to conduct a thorough search. They were looking for...
Yeah, they waited 10 months. That's what's kind of weird. You're arguing that these are some serious things, the heightened level of scrutiny and all that business as far as how they're going to attack it, and then they wait 10 months. Isn't the purpose of finding out if he's going through probation whether or not people in our community are safe? And if so, 10 months kind of seems to counteract that argument.
Yeah, I'm not happy about that delay either, to be completely honest. I will say that I understand their rationale to be when they get involved, to do so in a way that leaves nothing to chance. To have enough officers that they have total control of the situation from the moment that they intervene. I think there was some of the first officer's testimony where she said that's why they suspended home visits during that interstitial period, because they had concerns about safety where setting one or maybe two officers might potentially be putting them at risk.
Counsel, what do you make of Ms. Nye's point that in a sense there's an implied cooperation, even though the state officers aren't actually on this particular raid, implied in the sense that federal supervision checks like these will often come up with drugs or something that will fall below federal prosecution levels, and so it would be sort of expected that that would often be turned over to state officials, just as it was here. Help me with that.
So I agree with the observation that Ramirez already talked about the fact that if there is collusion or evidence of some sort of an agency relationship, something that turns the federal officer's action, gives the character of acting under color of state law, that would cause a problem. That would change our analysis here. It's not in this record. There's nothing that indicates that Des Moines police had no notice that this was happening until afterwards. Now, if this becomes a practice, something that they know that they can do and they take for granted before they go in, I'd like to see evidence of that, and that could help carry a burden. Now, I will say
So if that evidence was here, if we had take your opposing counsel's view, if that was a regular event, that when the feds went in to do supervised release checks, they were either going to charge federally if they got enough, or they knew that they would charge under the state. Would that in itself be enough to say that those federal agents were acting under color of state law?
So I don't think so. And I want to just parse that question a little bit, because what you said was they knew that they would charge under the state. What they did was notify the state, Des Moines police.
If they knew that they would either charge themselves or they would turn it over to state officers to use if they chose to charge. If that was a regular practice, would we have a reverse problem?
I don't think so. I think that generally the courts that apply an analysis like Ramirez look for something more, something that starts to take on the character of an agency relationship. And an essential element of agency relationship is the principal's knowledge, consent, and understanding that the agent is acting on their behalf. And there has to be some sort of involvement from the principal to create an agency relationship, to make it so that the agent...
Mr. Sloven, it looks to me like maybe from the record, based on the number of officers involved, guns, dogs, all that stuff, I think that they were planning on something big. It ended up being not much to write home about, and they gave the state some crumbs. It seems like they weren't even interested in charging. I have a question unrelated to that, but assuming something like that might have been how it was. Does Mr. Young's expectation of privacy in his home, does it matter that he's on federal supervised release as opposed to parole? Does that matter for any of our case law?
I don't think that it does, or at least it shouldn't. Now, I'm not saying that he consented in the meaningful way that would operate as a waiver of a privacy interest. What I want to point out with the supervised release terms is that the expectation of privacy, both subjectively and objectively, was markedly diminished. He knew that federal officials would search his home if they had reasonable suspicion. They wouldn't require a warrant to do so. And society recognizes that as reasonable, evidenced by the U.S. Supreme Court case in Knights and federal precedent that enables federal probation officers to do this. That matters in the special needs exception in the first prong of it. We can talk about that more, but I do want to talk about Ramirez because I think that's the interesting issue in this case. I do not think that Ramirez is distinguishable in any meaningful way. Ramirez, and the court quoted it in the ruling below in this case. Ramirez said that it doesn't sabotage the deterrence interests of the exclusionary rule, nor does it offend judicial integrity if federal officials comply with federal law and the federal constitutional commands and act without involvement of state authority, discover evidence while acting lawfully, and then turn it over to state officials who then use it, and perhaps it gets used in an Iowa criminal prosecution, that the admission of that evidence doesn't undermine our deterrence interests nor judicial integrity interests. And those are the two interests identified in Ramirez.
Well, Mr. Sloven, let me ask you about, I tend to agree with you if we just look at Ramirez, but I was trying to see, well, what's been decided since Ramirez? And the Vermont Supreme Court, for example, decided a case. I don't know if you read it, you're nodding, I think you're familiar with it. And that was one where it was a search that was perfectly okay under federal law. It was CPB agents stopping someone without any probable cause near the border, which the CPB is entitled to do. And instead, they found out it was an American citizen, but he had a bunch of marijuana. And so they turn it over to Vermont, Vermont prosecutes, and the Vermont Supreme Court throws it out and says, well, our state constitution, our equivalent of the Fourth Amendment protects privacy, and therefore we're not going to let this evidence in. If that's the rationale, then it shouldn't happen, right? I mean, then we should keep the evidence out, whether federal agents brought it to court or state law enforcement brought it to court.
So I think, and I'll point you to another case decided since Ramirez, which is Britain in Pennsylvania 2020. That court came out in the same way as Ramirez. There's a very interesting concurrence that kind of takes apart the multiple approaches and the different asserted interests behind the exclusionary rule. The interest you're mentioning, a privacy interest, a raw privacy interest, is not one discussed in Ramirez. Ramirez discusses the other two interests that the exclusionary rule protects. It deters officer misconduct, and it protects the judicial integrity of our courts. Now, the privacy interest is really not one that we frequently, we don't really see a concern for a raw protection of privacy in Article 1, Section 8 cases in Iowa. And I think this is something you point out, Justice McDonald, in your Burns concurrence, that the idea of that our exclusionary rule, to the extent that it is commanded, protects the other two interests, deterrence and judicial integrity. And those two, now deterrence, there's no deterrence interest advanced by, after the fact, saying that federal conduct offends a constitutional provision that they're not bound by, and you can't deter officers of another jurisdiction effectively from following their own procedures and acting as they're lawfully authorized to do. The judicial integrity interest, I think, is an interesting, what I find interesting is that when I see...
On that point, I mean, couldn't we agree that, let's assume the search violated Article 1, Section 8, if it had been done by state actors versus federal officials? And if our concern is judicial integrity, maybe under Ramirez, that's not an issue, but wouldn't it be better for a federal prosecution to protect our state court's integrity, the kinds of interests that we've decided that we're going to protect under the Iowa Constitution? Say if the federal government is conducting a lawful search, then they should just prosecute it in their courts, rather than passing along the evidence to a state court. And then we have no judicial integrity issue because it's lawful under federal law.
I mean, I disagree with that view of judicial integrity. I think it is more of a danger to judicial integrity for our courts to turn a blind eye to evidence lawfully discovered by agents acting within the scope of their lawful authority, right? And we all agree that the Iowa Constitution doesn't bind these federal agents. All we're talking about is what the exclusionary rule requires an Iowa court to do. And Justice May, as you point out, in that area, we're talking about the social costs of the exclusionary rule as well. We can't ignore that. The exclusionary rule imposes significant costs, and it's justified where those costs are outweighed by a benefit that the exclusionary rule provides. But judicial integrity in the form of just turning a blind eye to evidence that was discovered by officers who committed no misconduct, it's hard for me to see the advantage to judicial judicial integrity there. If anything, it turns this, more into a gamesmanship sort of an approach to.
Counsel, your brief advocates that we overrule State v. Short, but given our adherence to stare decisis, should we? Or why should we?
And it's a last resort. To even get to where that would be necessary, you would have to reject both of our other arguments. I think you would have to overrule State versus Ramirez, because I think it is fully applicable here. Just like in this, sorry, you asked about Short. Short doesn't mention the consent to search provision at all. I'm sorry, I see I'm out of time. If I can ever please do. Thank you. It assumes a privacy interest of the highest order of magnitude, which normally would be correct since we're talking about a person's house, but we're not. We're not talking about that in the ordinary sense because this person consented to a search and is under probation supervision, which creates a strong and societally accepted need for close supervision to make sure that they are complying with the rules of probation, rehabilitating, and not posing a danger to the community. So I think that Short also depends on semicolon analysis and a reading of the interplay between the reasonableness of the warrants clause that I think has proven to be incorrect. So if you don't overrule it here, I would say you should sue. Thank you.
Ms. Knight. Why don't you start with that conversation we were just having about the Short case?
Short. So, first of all, I don't think the sky has fallen since Short was decided, and I recognize that two of the dissenters in Short are here to correct me on that. But I think that, first of all, that to overrule Short, it would be effectively overruling a long line of cases that dealing with the warrant preference, that it's clear that under Iowa constitutional law, the warrant is required except in narrowly tailored circumstances and carefully crafted exceptions to that. And so I think that, there's a danger in overruling Short and how that would be done. That would overrule a lot of cases. And as well, I think it's important, and this sort of feeds into the other stuff I want to talk about, is that Iowa, we've recognized the special needs exception since then. And I think the special needs exception accounts for a lot of this concern. I don't think this search in this case was a normal search. This is not, when we look at King and we look at Brooks, this was a pretty extensive law enforcement type search. And I posit that most interactions between probation officers and parole officers or their supervisees are going to fall under the special needs and are going to be fine under the Iowa.
Even if that's true, we all agree, I think, that the search was lawful, correct?
Under federal law, yes.
And the Iowa Constitution doesn't regulate federal officers, so it was lawful for all purposes, correct?
Sure, yes.
So if that's true, then could you address Mr. Sloven's argument that it would undermine judicial integrity to exclude evidence from a trial that everybody agrees was lawfully obtained?
I think it was lawfully obtained under federal authority. I think that the other purposes of the exclusionary rule apply. The judicial integrity, that we're talking about Iowa citizens who have rights under the Iowa Constitution. And so judicial integrity would require excluding the evidence, because otherwise the judges, the courts become complicit in the violation.
All right, well, let me give you an analogy, Ms. Nye. We have an inevitable discovery rule here in Iowa. So we say that even if the search was conducted by state law enforcement and in violation of the Iowa Constitution, we as judges will let it in if it's shown that the state would have discovered it anyway. And I don't think that impairs our judicial integrity. this. I hope it doesn't, because we've been doing that for a long time. So how do you distinguish that?
I just think, you know, it ultimately, it's because, you know, I just think that when you look at all the purposes of the exclusionary rule, that when you have a search that in that way that's a, you know, a clear violation of the Iowa Constitution, and that exception might apply in a different situation and would let the evidence in. Sorry, I don't think I have a great answer that there are exceptions that are recognized and some that are not.
Counsel, just to play this out a little bit further, suppose that an Iowa citizen were convicted of a federal felony based on evidence that's okay federally, but would not pass muster under Article 1, Section 8. So they've got this felony charge, and then that felony becomes a predicate for, say, felon in possession of a firearm in front of our state court. Should we look back and say that felony wasn't good enough because it was only good enough under federal law and not good enough under the state constitution?
That's an interesting argument. Make a note of that. I don't think that's warranted by holding that this should be excluded. And I do want to point out that there are. Again, it sort of goes to the sort of dead body example that most interactions between supervising officers and the supervisee are going to fall under the special needs exception. They're generally, this just because this particular case I'm here arguing is excessive doesn't mean most interactions are excessive.
Don't you think it's excessive because they didn't get hardly anything? They did get crumbs. I can't help but think that 14 people, all the planning was put in, they were planning on something big. So, I mean, for you to call it excessive, aren't you only looking at the result?
No, I still hold that what they were looking for, you know, I mean, if they come across pounds of methamphetamine, that would, if I can finish, sorry.
Please do.
You know, I don't know where that would have been found, but they were looking, you know, the sort of detailed items that they were looking for that would prove a prosecution, not just a violation that he was possessing drugs or using drugs, but that he was distributing them, and looking for the evidence to build a case of distribution, not just possession or failing on probation.
Maybe your guy got wind of it. I mean, my goodness, 10 months transpired between the time the confidential informant notified someone and they actually exercised their search. Isn't it possible that he unloaded everything? Maybe they were gonna.
His testimony, his statements were that he used to deal, that he had been dealing in the past and had stopped, and the jury believed that because they acquitted him of the distribution charges. So that, I mean, in some ways, I don't know, he quit for whatever reason, but that was his statements. And I could just briefly point out that they can still revoke his parole or supervised. They could change his conditions. Like, he's not. If they can't get this into state court, it doesn't mean he walks away scot-free. They could still prosecute federally, just if federal authorities decided to exercise their discretion not to. They still have the authority to prosecute him federally or impose further sanctions on his supervised release.
Thank you. The case of State versus Young is hereby submitted.